And what about injuries?
All right, counsel could...
Lindsay Clancy breaking down multiple times in the courtroom.
Did you form an opinion to a reasonable degree of professional certainty, to medical certainty, as the cause of death of Cora?
Yes.
And what was that?
Asphyxia.
Meanwhile,
The record opens with a question no parent should ever have to hear in a courtroom. And what about injuries? The answer came in one clinical word: asphyxia. That exchange is not the loudest moment of this trial, it is the quietest. And that is exactly why it matters. Picture a single frame, a doctor on a screen, a mother on the other side, and between them a drop-down menu that allows only 3 options for a human being's deterioration. That image is the entire case. Before we go deeper into what the documents actually show, make sure you're subscribed to Law and Crime Insiders. Because we don't just cover the story, we follow the evidence.
Meanwhile, bombshell moments from Lindsay's former prescriber when things get tense on cross-exam.
I know it doesn't say not, but that is exactly what I meant.
Wait, when did you see this that you noticed that it did not say not?
I don't care what it says. I know what I meant.
Plus, could a viral TikToker be called as a witness?
I'm a Massachusetts social worker, and I also worked on the exact inpatient unit at McLean for nearly 8 years that Lindsay Clancy was a patient at.
This woman posted a video on TikTok, which, much like yourself, I'm sure, I hardly know what TikTok is.
And one thing no one could have predicted, this comment from the defense.
Cannabis, the weed, the devil's lettuce. How about that?
Bombshell number 1 landed in the cross-examination of Lindsay Clancy's former prescriber, Dr. Jennifer Tufts. The medical record said not hyper-pressured speech. Under oath, Dr. Tufts said, "I know it doesn't say not, but that is exactly what I meant." Then she said the sentence that should be stamped on every exhibit. "I don't care what it says. I know what I meant." That is not a typo. That is a medical record in a triple homicide. The chart was updated, the woman was not.
Right. All of their appointments, 14 appointments, were done in telehealth.
Elena is right. That's something everyone is talking about. The fact that Dr. Jennifer Tufts, Lindsay Clancy's former psychiatrist, never once saw her in real life until the trial began.
14 appointments?
Yes.
Every single one of them were by telemedicine, weren't they?
Yes.
Until you came in this courtroom Friday, you never saw this woman in person, did you?
Correct.
And did you give her a hug? Oh no, you're on telemedicine, so you couldn't give her a hug, could you?
On top of that, Dr. Tufts was a relatively new doctor at the time she first saw Lindsay, having only officially practiced in that space for about a month before Lindsay became her patient. She's also a name you might recognize, as she's listed as a defendant in the civil lawsuit alleging medical malpractice. Here's what she has to say about all of that.
I do not believe that I have been negligent.
Bombshell number 2, Dr. Tufts never saw Lindsay Clancy in person until the trial. 14 appointments, every single one by telemedicine. Not one hug, not one in-person look at a woman she was treating for anxiety, depression, and later suicidal ideation. And bombshell number 3, she had been independently practicing for about a month before Lindsay became her patient. She testified she treated 0 patients for postpartum psychosis in that month. 0. Yet she was the prescriber managing a postpartum patient's psychiatric medications.
You're a defendant in a very large lawsuit, are you not?
Yes.
You wouldn't happen to be represented by an attorney, would you?
I am.
And the fact that you have an attorney is your right under the Constitution. It doesn't mean that you're guilty of anything, right?
Right.
Okay. And you know that the outcome of this case is very, very major to the outcome of your lawsuit. Is that right? Oh.
I don't actually know that.
So you understand that if, in fact, it's determined that you advertised as an expert in postpartum and in postpartum psychiatry, and you had a month experience plus a residency, would you consider that to be negligent or misrepresentation?
I do not believe that I have been negligent.
Dr. Tufts was called to the stand last Friday by the Commonwealth, but this week her testimony began with cross-examination, questions from the defense. She testified she received her board certification in August 2022. She then saw Lindsay Clancy for the first time just weeks later on September 15th, 2022.
So you were practicing as a psychiatrist for a little more than a month.
I was practicing independently with my full credentials for about a month, but the training is just immense that goes on before that.
Now, in August of 22, up until when you saw Lindsay, how many patients in that month or so had you treated for postpartum psychosis?
How many patients in a month up until that
Yeah,
month?
I'm asking you about when you started working in August of 22 for Astor, and you are now on your own as an employee. How many patients had you treated before you saw Lindsay Clancy for postpartum psychosis?
Well, in the span of 1 month, I would say none, because it's a very rare disorder.
Okay. But it exists, doesn't it?
Absolutely.
And one of the things would be the voices that people hear, right?
That is a symptom of psychosis, absolutely.
And that's legitimate, isn't it?
It is a legitimate diagnosis, absolutely.
It's not the diagnosis. People that have postpartum psychosis hear voices, do they not?
Many do. The disorder can manifest differently in different people, but yes, many people do hear voices.
How about postpartum depression? How many people in that month or so before you met Lindsay did you treat for postpartum depression?
In the span of 1 month, it's really hard to pinpoint that. Maybe a couple.
Maybe a couple? And do you recall how long you treated them for?
Again, it's hard to really pin down the individuals in a short span of time.
Dr. Tufts testified Lindsay came to her with issues of anxiety and depression, but she never saw Lindsay in person.
She had 3 kids, right?
Yes.
And the reason that you knew that she was married is because you spoke to her husband, Patrick, correct? Or did you?
Sorry?
Or did you?
He attended one of the appointments, and I spoke with him on that date.
Ah. And did you say, hi, how are you, and give him a handshake when you came in your office?
It was telemedicine.
It was what?
Telemedicine.
Telemedicine.
Bombshell number 4 is the legal conflict the prosecution never wanted front and center. Dr. Tufts is a defendant in Lindsay Clancy's civil lawsuit alleging medical malpractice. On cross, she said she does not believe she was negligent. The defense hammered the point the outcome of this criminal case could shape the outcome of her civil exposure, and then the questioning turned to the physical distance. You're on telemedicine, so you couldn't give her a hug, could you? Dr. Tufts answered, I could look at her. It was a video appointment. Look at her. A woman reporting she could not get out of bed. A woman reporting she wanted to die. The chart was updated, the woman was not.
The defense pointed to Dr. Tufts' use of the word deteriorating when describing Lindsay's condition as the treatments went on.
She was a little bit worse at certain appointments, and the deteriorating word, which is not my word choice, is what is in the note because I had to select that.
Because why? You have some kind of a program that you have to check the box and you have to bring down the drop box? You can't take a pen and write something down about a patient?
There are certain parts of the note where I can write whatever I feel is necessary, but that specific aspect of the note is a button where you have to click one of 3 choices. I didn't say she was terribly depressed in that initial visit, but she said she was anxious and she appeared anxious. That's pretty congruent.
Okay. So did you put in the report that she was congruent or incongruent?
So that is not an option for me to indicate in that section, but
So-
it was congruent.
You're like a robot. You can't take a pen and write something down. You have to do the drop box and the X's on the computer?
Well, if it's on the computer, I'm limited by the options that are up there
You're a doctor. Why are you limited?
because of the technology.
What technology? The fact that there's a form on a computer? You're trying to treat a human being who comes to you for help.
And that's what's most important. What's most important was the treatment, not what is checked off on a box.
It was Dr. Tufts who prescribed Lindsay the medication Zoloft in fall of 2022.
Suicidal ideation and homicidal ideation. There's a black box warning on Zoloft, along with other SSRIs, right?
Under
Yes
age,
or no?
for children and adults younger than Lindsay.
Excuse me, doctor, I apologize. Can you just listen to my question and answer it yes or no? Is there a black box warning on Zoloft?
Yes.
Okay. And a black box warning is required or prescribed by what, the FDA?
Probably.
Probably. And it basically warns that, especially with young people or young adults, that it may cause suicidal or, God forbid, homicidal ideation. Yes?
Yes.
And things are getting tense. Dr. Tufts and Kevin Reddington, the defense attorney, talk over each other as the cross-exam goes on.
Now, when you were going over the symptomology or when you were going over the side effects of Zoloft, one of the side effects of Zoloft is, and I quote, severe trouble sleeping, right?
Yes.
Did you tell her that?
Well, insomnia is listed as a side effect.
No. You already said yes. You know it. Did you tell her that Zoloft has a side effect of giving the patient severe trouble sleeping? That's all.
So I didn't use the word severe because it typically doesn't cause severe trouble sleeping, but I thought you were referring to when she told me that she did have severe trouble sleeping, and that was true.
That's what she told you, right? That she had severe trouble sleeping, right?
She told me, yes.
And you know that one of the side effects of Zoloft is, let's say, trouble sleeping. You know that, right?
Yes.
Your answer is yes. The jury has to be able to hear you.
Yes.
And why would you prescribe Zoloft to a young woman who's postpartum, who's coming to you with anxiety, who's telling you she can't sleep, she's got all of these symptoms, and you prescribe a medication that would have a side effect of trouble sleeping?
So individuals have very varied responses to medications. Some have no side effects, some have one or two. It's impossible to predict, but Zoloft is a top choice, a first-line medication for her.
Says who?
Says it's the general consensus
Right, know
among
about the lawsuits
psychiatrists.
against
Hold on,
Zoloft, right?
again, we can't have both of you talking at the same time. So let her finish her answer, and then I'll give you plenty of time to follow up any questions regarding her answer. So, you finish your answer on that?
There's extensive research supporting the use of sertraline in this instance, and the general consensus among psychiatrists is that it's a first-line safe medication for individuals, including postpartum women.
Reddington pokes holes.
Bombshell number 5 was buried in the software. Dr. Tufts said the word deteriorating was not her word choice. It was selected from a drop-down menu because the electronic medical record allowed only 3 buttons. The defense asked if she was a robot. She replied, "I'm limited by the options that are up there." Then came the Zoloft black box warning. She prescribed Zoloft to a postpartum woman reporting severe insomnia. Even though trouble sleeping is a known side effect, she testified Zoloft is a first-line medication. The black box warning includes suicidal ideation and, in rare cases, homicidal ideation. The form was filled out. The risk was not.
No sleep last night. Falls asleep after 40 minutes. Heart racing, severe anxiety. Worrying about kids, baby, sleep. Yawns but not drowsy. Not hyper, pressured speech.
What was that? Not hyper what?
Not hyper, not pressured speech is what I meant. I know it doesn't say not, but that is exactly what I meant.
Wait, when did you see this that you noticed that it did not say not?
I don't care what it says. I know what I meant.
Well, when you wrote this, you did not say not pressured speech. You said in the medical record, pressured speech, right?
No.
Does it say that?
Yeah, the word is The word not is right before not hyper, comma, pressured speech. The
Right, so
two
what
are
does
following
comma
the
mean
not.
to you? When you put down in a medical record, heart racing, comma, severe anxiety, comma, worried about kids, comma, baby, comma, sleep, comma, yawns but not drowsy, period. Not hyper, comma, pressured speech. That's what you wrote, right?
She did not have pressured
Did you write
speech.
that, doctor?
I wrote that, but you're misinterpreting my note.
Am I reading this correctly, and the jury will be able to look at it, that you put not hyper, comma, pressured speech? Did I read that right?
Yes, but your interpretation is incorrect.
When Lindsay expressed suicidal ideations, Dr. Tufts testified she still didn't recommend seeing Lindsay in person.
And on December 1st is when she told you, again, that she was close to having suicidal ideation, feeling hopeless. Do you recall that?
Yes.
Now, on the interval history, on that date, you indicated that she can't sleep, she's panicking, she had worse depression, intrusive thoughts, she was numb, nothing mattered, I feel like I'm going to die, denies suicidal ideation, but, quote, yesterday, close to it, feeling hopeless. Did you give her therapy and validations after she told you that?
I believe that I did.
What did you do? You got a woman that's telling you that she's hopeless. She doesn't care if she dies. Can't sleep. What did you do to validate on your therapy?
Well, I told her that this was something that we could address, that there was hope, that there were treatments, and there are different types of treatment programs that are more supportive, like partial hospitalization programs. So she knew that she still had options and a reason to hope.
Did you ever suggest to her that maybe you ought to come in to see me rather than talk on the computer?
Talking with her over the video did not seem like an issue. It didn't seem like there was anything that I was missing or that there was any need to see her in person.
The note itself became bombshell number 6. On December 1st, Lindsay told Dr. Tufts she was close to suicidal ideation, hopeless, numb, unable to sleep, feeling like she was going to die. Tufts did not recommend an in-person visit. She said the video sessions did not seem like there was anything I was missing. The defense read the exact record, not hyper, pressured speech. Dr. Tufts said the interpretation was incorrect. This is the gap between what was officially said and what actually happened.
Things were spicy for Dr. Tufts. That was not at all the case with nurse practitioner Julie Paul, who Lindsay was recommended to by her mother-in-law, Susan Clancy.
Yes, I asked her specifically if she felt like she wanted to harm herself or her children, and she said no.
And how about asking her about homicidal ideations?
Yes.
And did she indicate whether she had any?
She did not.
Did you also ask her whether she had experienced any auditory hallucinations?
I did.
And did she experience any?
Not at the time, no.
And did she indicate to you whether she'd ever experienced any?
No.
How about visual hallucinations? Did you ask her about those?
I did.
And did she indicate that she had experienced any?
No.
And delusions, did you ask her whether she had any delusions?
I didn't ask specifically about delusions, I believe.
Paul stated that Lindsay tested very high for anxiety, but not suicidal ideations. When Paul moved out of state in late November 2022, Lindsay was then referred to nurse practitioner Rebecca Gelada, who is also listed as a defendant in the civil lawsuit.
And as far as your observations of her presentation, like her mood and physically how she presented, did anything stand out to you as far as any of that?
She seemed anxious.
Okay.
Do I remember?
Okay, so as far as mood.
So I couldn't hear that.
Sorry, if she can finish her answer.
Sure. You done with that?
Yeah, I'm done.
Okay, all right.
So as far as mood, you noted her to be anxious, right?
Yes.
And you also look at a person's affect.
Mm-hmm.
And did you?
You're gonna have to answer yes or no.
Yes, sorry.
You observed her affect to be consistent with her mood, which you identified as anxious, right?
Mm-hmm.
And you examined somebody
Yes.
for their.
Sorry.
That's okay. Thought process, right?
Right.
And what did you observe her thought process to be?
I observed her thought process to be linear, meaning you could follow it, her train of thought easily, and goal directed. She understood that she was there to be assessed for treatment. Seemed to be her goal.
Gelada testified Patrick Clancy was allegedly dismissive when she discussed a possible diagnosis of bipolar disorder.
Did you express to Ms. Clancy thoughts that you had about her diagnosis based on your interactions over the last few weeks?
I did.
And what was that?
I discussed with her and her husband the possibility of potentially an underlying bipolar disorder. I based this on several factors, one of them being that she had such what we call an activating response to the Zoloft. It's unusual for somebody to describe taking Zoloft and then going 48 hours without sleep and not being tired. So that raised my clinical suspicion a bit. And she had been, I would say, having difficulty tolerating other antidepressant medications that we had been trying to have her take since then. And so again, I'm wondering if it's because potentially there might be an underlying, what we call mood disorder, bipolar disorder.
And as far as the information that you had about her past psychiatric history, were there any indicators to you about manic episodes?
No.
And so while you noted that there were some concerns reported, did what was reported to you rise to the level of diagnostic criteria for bipolar disorder?
Not at that time.
And when you explained this to them, your thoughts about her reactions to the medication and these reported prior symptoms, did Patrick and Lindsay seem receptive to your diagnosis?
I recall Patrick saying my wife is not bipolar. Lindsay looked at me. She did not say anything.
Bombshell number 7 came from a different clinician. Nurse practitioner Rebecca Gelada testified she raised the possibility of an underlying bipolar disorder after Lindsay had an unusual activating response to Zoloft, going 48 hours without sleep and not being tired. She testified Patrick Clancy said, "My wife is not bipolar." Lindsay said nothing. That silence is now part of the record. Gelada also observed no psychosis, no mania, no delusions at that time, but the warning was documented. The system heard her, it just didn't act.
The same day jurors heard all of this testimony, there were discussion outside of their presence involving a TikToker.
Your Honor, basically, as the motion speaks for itself, there is a woman, her name is Emily Thorndike, who's a LA CSW here in Massachusetts. She owns and is an independent operator of her own clinical social work establishment called Wise Mind Therapy.
That's this woman who made a TikTok a few weeks back. She used to work at McLean, the medical facility Lindsay Clancy stayed at in late 2022 and early 2023.
When a patient is admitted to the unit, they are specifically assigned two clinicians. One is a psychiatrist, and the second is the social worker. You are literally told as a patient, this is your treatment team. This is your doctor. This is your social worker. With that being said, legally, every patient needs to be seen at least once a day by a doctor. So on the weekends and on the holidays, when the physicians in charge, the regular physicians who are working there, are off because they work weekday hours, on the weekends and on holidays, the patients still need to be seen by a doctor. How that works is that there is one doctor who comes on the weekend and holidays, and he or she sees every single patient on the unit, okay? And if you think about it, there's a reason that the doctors who are there during the week are only assigned 4 to 5 patients, because you cannot spend a long amount of time as a doctor with 23 different patients.
Last week, the defense made it known they want to call Emily as a witness. Their motion reads in part: Ms. Thorndike literally worked the unit that Lindsay Clancy was presented to on New Year's 2022-2023. Ms. Thorndike would testify based solely upon her firsthand observations and 8 years of experience while employed at McLean Hospital's short-term unit between 2014 and 2021.
She left, as the court is aware from the motion. I vetted her out. I obviously would be concerned if there's any so-called axe to grind, if you will, any lawsuits pending. Were you fired? Did you have any difficulties? Any claims for harassment, hostile workplace? Absolutely nothing. She has friends that are still employees that still work at McLean. And I do not know this woman. I have literally never met her. Her involvement in this case came about after one of the prosecutors, I don't recall which, made it out on direct examination that McLean is some kind of a 5-star institution where the doctors, the psychiatrists, the psychotherapists, the counselors were all banging into each other in the hallway trying to interview Ms. Clancy, who was just blithely refusing care and treatment, which is not the case.
The Commonwealth had some reservations about this potential witness.
Aside from that, we have a number of other issues with this witness. One is this isn't somebody that's proposed to be an expert, so they're not relieved, they wouldn't be relieved of a sequestration order. But this woman's TikTok, admittedly, she's been following the trial. She goes on for several minutes in a very long TikTok video where she identifies what she thinks are lies based on her observations of Patrick Clancy's testimony. We have no idea what her thoughts are or what her comments are on the rest of the trial that we assume she's watched based on her comments in this particular video. That she outlines in this video her experiences at McLean and her observations and how they are different from what was portrayed in that particular witness's testimony.
Bombshell number 8 is the witness no one expected: a TikToker. Emily Thorndike, a Massachusetts social worker, worked on the exact McLean Hospital unit where Lindsay was admitted over New Year's. The defense filed a motion to call her as a witness, arguing she could rebut the prosecution's portrayal of McLean as a 5-star institution with clinicians banging into each other in the hallway. The prosecution objected, noting she had posted a video about the case. The judge took the motion under advisement. That is the first time a viral TikTok account has become a potential evidentiary exhibit in a triple murder trial. The line between public opinion and court record just got thinner.
Meanwhile, the Commonwealth continued their arguments with more testimony from medical professionals who treated Lindsay.
Now, at any point that you were interacting with her between December 2nd and the last contact with December 27th, albeit limited, did you ever have any concerns about her physical well-being?
No.
Did you ever have any concerns about the physical well-being of others in her presence?
No.
Did you ever see or observe any signs of mania, delusion, or paranoia?
No.
Any signs of psychosis observed by you?
No.
Did you ever have any difficulty understanding what she was saying or notice any differences in her speech patterns?
No.
Did you ever have any concerns that she wasn't accurately reporting things to you?
No.
A mental health counselor testified she saw no signs of mania or psychosis when observing Lindsay. On cross-exam, she discussed Lindsay's substance use.
She said her alcohol of choice was wine. She would have 1 to 2 glasses.
Did she say why she would do that?
To cope with anxiety.
Okay, and this is back in 2019, right?
Correct.
That would be 3 years before you actually met with her in December of 22, right?
Correct.
Cannabis, the weed, the devil's lettuce. How about that? Did she confess that she was using marijuana?
Yes, she said she did use marijuana.
When?
Last use was November 15th, 2022.
Why?
I'm sorry?
Why did she say that she used it? It's under comments?
Yes, I'm taking it.
That's okay.
She said she tried a marijuana gummy to help with sleep.
And that was on November 15th of 22, right?
Yes.
The defense alleges Lindsay was screaming for help and no one answered, even after she said she had suicidal ideations and called a suicide hotline.
She met with a clinician virtually and was told that she did not meet the criteria for inpatient treatment due to not having any suicidal ideation plan.
So if she said, in addition to the fact that she's been in counseling and therapy and seeing psychiatrists and on medications for the past 3 months or whatever the period ultimately would be, and that she wanted to kill herself, didn't want to be here, couldn't care if she died, they told her because she didn't have a plan that they couldn't help her?
Correct.
Did they, to your knowledge, make any recommendations? Or did they recommended that she attend a day program?
Yes.
All right. And that person from Aspire then said he would send her patient resources, right?
Correct.
But nothing ever happened. He never sent her any. You did, but he never sent her any patient resources, right? If you know.
Not to my knowledge.
Okay.
But
Then came bombshell number 9, the crisis line that did not send help. Lindsay called a suicide hotline, reported suicidal ideation, and was turned away because she did not have a specific plan. The clinician said she would send patient resources. They were never sent. Here is the ticking clock. If a woman tells a crisis line she wants to die but has no plan, how long does the system get before the plan becomes an autopsy? In this case, the answer is measured in weeks, and the defense also highlighted a marijuana gummy Lindsay tried for sleep, which the defense called the devil's lettuce. It sounded absurd, but it was a window into how desperate she was for sleep.
But things got really emotional when a medical examiner was called to the stand.
How long, based on your training and experience, does it take for a brain to start dying after the loss of blood flow and oxygen?
It varies based on different sources. Most sources say it's between about 6 to 8 minutes. If there is no oxygen flow, then the brain will essentially start dying. It depends on, if there's resuscitation that occurs afterwards, but it's generally in the frame of 6 to 8 minutes or so.
And once brain tissue dies, it can't be brought back, correct?
Correct, yes.
I have nothing further, thank you.
You're welcome.
Reddington? Hold on, Counsel, hold on. We're going to take a short break, all right? So why don't this will be a very short break, come out, we'll come right back, okay?
Court, all rise. Jurors, close the notebooks. Please come to chairs, please. This way.
Session. All right, we'll be in a short recess in the courtroom.
Everybody, clear the courtroom.
Lindsay broke down 3 separate times on Wednesday, including when a forensic pathologist discussed Cora and Dawson's autopsy findings.
And did you perform an autopsy on Cora Clancy on January 25th, 2023?
Yes.
And did you follow that same process with Cora Clancy?
Yes. And then I noted evidence of trauma of the neck with associated injuries of her head and minor injuries of her right arm and of her legs as well.
And in terms of the injuries that you observed, evidence of trauma to her neck, were there also injuries to her face and neck area that seemed to go along with the trauma to her neck?
Yes, there were findings of the head that were associated with the trauma of the neck.
And what were those?
So on her neck, she had a ligature furrow.
As the testimony continues, you can literally hear Lindsay breaking down.
So again, the furrow is a ligature is when you have external compression by an object on the neck, and a furrow is simply a pattern of injury that occurs beneath it. It can be an imprint, it could be a pattern, or it could be more developed types of injuries such as bruising or abrasions.
And what about injuries?
You can actually hear Lindsay crying, saying, "I can't do it."
What about injuries?
The judge even notices this and calls for a break.
All right, counsel, we're going to take a break this time, all right?
All right. Jurors, close your notebooks. Place them on the chairs, please. This way, please.
Recess for a few minutes. I'm going to come back. We'll speak to counsel in regards to schedule. Okay.
When court reconvenes, Lindsay's head is on her desk and she continues to cry during the testimony.
So your testimony is that you can strangle someone for 30 seconds, let go, and then they die.
I said that in this presence of complete oxygen deprivation, there is a general time frame, and so 30 seconds, I cannot give a specific number to that. Once strangulation occurs, again, the brain starts to be subjected to a lack of oxygen. So whether the ligature is present or whether the ligature is not present, the oxygen deprivation and irreversible brain damage is already occurring.
And there's no coming back from that?
Not without intervention. It's very unlikely. Again, the brain cannot heal those cells.
Did you form an opinion to a reasonable degree of professional certainty or to medical certainty as the cause of death of Cora?
Yes.
And what was that?
Asphyxia.
And was that by manual strangulation?
The final bombshell is not a document. It is Lindsay Clancy herself. During medical examiner testimony, she broke down 3 separate times. The judge called a recess. The forensic pathologist testified that the brain begins to die after 6 to 8 minutes without oxygen. Then, the cause of death asphyxia. The chart was updated, the woman was not. That phrase now has a body count.
When you're looking on the target's phone, and out of this whole courtroom, the target would be Lindsay Clancy, right?
Yes, sir.
All right. And you had access to her phone, right?
Yes, sir.
And you all went into it with a search warrant, right?
Yes, sir.
And you were looking for different topics, such as suicide, drugs, killing kids, I imagine, to investigate, right? You had buzzwords.
Yes, sir.
And did you come across, for example, a search that indicates carotid artery?
I don't recall.
Did you come across a search on Safari, how to slit your throat to die?
I don't recall.
Did you come across a search, can you turn airbags off on Kia Sorento?
I don't recall.
Did you know that she had a Kia Sorento?
I did not.
Meaning, is it possible the searches were made by Patrick rather than Lindsay?
These all came from Lindsay's phone, right?
I can't confirm that.
Wow.
One more hard question emerged from the phone evidence. A digital forensic examiner testified the search warrant targeted Lindsay's phone. Buzzwords included suicide, drugs, killing kids. The defense asked whether the phone contained searches such as, how to slit your throat to die, or can you turn airbags off on a Kia Sorento? The examiner could not confirm who made those searches. That matters because the state's digital evidence assumed one user. The record cannot tell us whose fingers typed the worst question. Before you decide, pull one document. The defense motion to call Emily Thorndike as a witness, available through the Massachusetts Trial Court electronic docket. Read the staffing claims and ask yourself one question. If McLean's unit was as fully staffed as the prosecution implied, why did a private investigator have to track down a social worker who worked that holiday weekend? If you want more evidence-driven breakdowns like this, share, subscribe, and turn on notifications for Law and Crime Insiders.